Most Florida lawyers tell clients you can't disinherit a spouse or minor child from the homestead. That's true, except for the part where you can. The Florida Constitution restricts how you devise the homestead at death. It does not restrict how you hold title during life. Title beats devise every time, and we see this go wrong a lot more than people would think. I'm David Shulman, and I'm here with my partner, Jill Ginsburg. The rule everyone has heard about is that if you die owning a homestead and you're survived by a spouse or a minor child, you can't devise that homestead away from them. Spouse and kids are protected. Most clients have heard some version of that, and that's the part that makes them relax about the house. They figure, okay, Florida law has it handled. However, that rule does not apply to property that the decedent owned as tenancy by the entireties, which I'll call TBE, or in joint tenancy with right of survivorship. If the decedent's title at death is joint tenancy or TBE, the homestead protection does not apply. The decedent's interest just evaporates at the moment of death, and the surviving co-tenant takes free and clear under the deed.
So the protection only does its work when there's actually something in the estate to protect. By the time the family calls us, the deed is usually recorded, and they're fighting about a house that isn't even part of the estate.
That's right. And the Florida courts have drawn the line in pretty clean language over the years. The Constitution restricts what a homeowner can devise at death. It does not restrict the kind of title a Florida homestead homeowner can hold during life. So a homeowner can take title in a way that practically cuts out a spouse or a minor child, and the Constitution has nothing to say about it.
And that's the piece that catches clients off guard. They assume the protection covers the property no matter how it's titled.
The most common fact pattern we see is the second marriage. Mom owns the house outright going into the marriage. New husband says, well, we're a couple, we should put the house in both our names. Mom signs a survivorship deed. Then mom dies first. Mom's kids from her first marriage walk in expecting Florida homestead law to put the house in play, but it doesn't. The house belongs to the new husband, free and clear.
And on my side, I see the next chapter of that. The new husband dies 5 years later. His kids from his first marriage take the house, and mom's kids end up with nothing. The protection that they thought they had ran on title that no longer existed at the moment mom died.
And the other version, Jill, is adult child says, Mom, put me on the deed so I can help you. Joint tenancy deed gets recorded and mom dies. The other siblings come in assuming the house is in the will, and the answer is the will doesn't get to that house. The kid whose name went on the deed owns it. The other siblings have no homestead claim because at the moment of death, there was no divisible interest left.
And that one usually shows up in my office as a guardianship flavored problem. The other siblings come in saying, wait, who got mom to sign that deed? Was she competent, and were we even told? It turns into a fight about capacity, sometimes undue influence, sometimes both. By the time it gets there, undoing the deed is a much harder lift than it would have been to plan in the first place.
That's right. And here's the piece that really doesn't get talked about even by other lawyers. The Florida Constitution does have a partial break on this. Article 10 of the Constitution also requires a spousal joinder for any inter vivos, means during life, transfer of the homestead. So if you're married and the homestead is in your sole name, you cannot just unilaterally execute a joint tenancy deed, putting someone else on title. Your spouse has to join the deed. That rule has teeth. It prevents a married homeowner from quietly retitling around the spouse's homestead protection.
But that break only works if there's a spouse to do the joining.
Exactly. There's no equivalent rule that requires a minor child to join a deed. So an unmarried Florida homeowner with minor children can unilaterally sign a joint tenancy deed, putting the home in joint names with a new partner or with an adult relative. That deed is valid. At death, the Florida statute 732.4015 carve-out implies the homestead protection evaporates and the children's constitutional inheritance protection has nothing left to attach to. The Constitution protects a spouse from this kind of unilateral retitling. It does not protect a minor child from it. The entire homestead inheritance right of the children can be defeated by a single deed signed during the parent's life.
And that version is the hardest one to undo because by the time someone's paying attention, the parent is gone. You can't go back and ask whether the parent really understood what they were signing or whether somebody else got the parent to sign it. The kids are maybe stuck with the deed.
So here's the practitioner takeaway. If a client wants to control the homestead at death, The first document I look at is the deed, not the will, the deed. If the title is already joint tenancy or TPE with the wrong person, the rest of the estate plan has nothing to say about the house. While the homeowner is alive, there's still time to fix it with a corrected deed. But once the homeowner dies owning a joint tenancy, it's done.
From the elder law side, this is why we also want to see the deed before we have any conversation about the rest of the plan. Families come in thinking we're going to talk about the will, but the real answer is the will isn't the document that decides this. The deed is already decided.
The homestead constitutional protection is real. It just only protects what is there to protect at the moment of death. So the lesson is to look at the deed before you read the will.